tired and I want the opportunity to get my life together. I'm tired of this. I'm tired of this. Oh, I miss my daughter's graduation. She spoke at Westbrook graduation. I was not there. I'm tired. My baby asked me why I'm the only mom. I'm not at mom's and muffins. That is embarrassing for my kids. I was also my kids. Yes, ma'am.
And Ms. Rideau was previously in court, entered pleas of guilty in cause numbers 23-0928, 23-2106, 23-2107, and 24-1925. All of those were theft of property with previous convictions. I have received the pre-sentence report. Has that report?
I think so.
State has, Judge.
And there was no agreement. This was just open to the court. Is that correct?
Yes, Your Honor.
I believe so, Your Honor. I didn't represent her at the stage where she entered the plea.
Okay.
My understanding is that
They were open. And are there any additions or corrections to the pre-sentence report?
None from Defendant.
Not from the state, Judge.
In addition to reviewing that, the state has filed a couple of things. One is a motion for me to run any sentences consecutively, which means obviously stacked on top of each other. And I think I could do that in, I think 2106 and 2107, maybe not. But is that,
Judge, I think,
are they different dates?
I think they're all different.
Are they?
But
Hold on, I'm looking. Yeah, they're different dates.
let me make sure. I think all four of them are.
They are. All right, so asking me to stack any sentences, and then he has filed a sentencing memorandum as well, in addition to a motion for me to deny discretionary jail credit. So, Mr. Kimler, if you would like, you may proceed.
Buckle up,
Yeah.
guys, because this sentencing starts with pure emotion and ends with the state coming in heavy. The defendant breaks down over missing her daughter's graduation and not being there for her kids, but the court is already focused on the hard facts: 4 theft cases, prior convictions, and a clean plea with no deal. Then the hammer drops. The prosecution wants stacked sentences and even jail credit denied.
Yeah, I just note that seems to be an aberrant practice as far as its harshness that the state is attempting to exert on this defendant, and I don't know that it stands out from the queue of other cases before this court to deserve such treatment, but it is what it is. I would just observe, first of all, regarding the state's posture on consecutive sentences to denial of discretionary jail credit. The defense certainly has criminal history, but it's not to such an extent or degree in the circumstances the individual cases aren't such to the extreme degree that it would warrant accumulation, and certainly the denial of her jail credit is something that is problematic. I don't know exactly which jail credit the state is attempting to deny her, but obviously if she's been in pretrial detention on these cases, it seemed that she would be entitled to that jail credit without much controversy. What grounds the state would be attempting to deny that, I don't know, but of course we would argue that she should receive credit as every other defendant before this court has for the jail time credit that they've done pursuant to these cases. I would note that the pre-sentence report indicates that she does have mental health history dating back to her time in the military, where she was discharged. She had a general discharge, and that there was notations there as far as the pre-sentence report that it would involve some health issues. I believe her to be mentally competent. Now, I, of course, wasn't her attorney when she entered the plea, but I would assume that she was mentally competent then as well. Although, as I said, she does have mental health history. I think that plays into her present situation with the theft cases that she has. You will note in the pre-sentence report where it's indicated that she was unable to afford the mental health treatment and the pharmacological remedies that are provided through prescriptions, and that she was self-medicating and had turned to theft in an attempt to maintain funds necessary to self-medicate. She indicates in the report that her memory indeed was impaired on 3 of these offenses, and she doesn't seem to remember those. She doesn't attempt to minimize or mitigate her conduct in that regard, where she does in fact indicate that she accepts responsibility fully for her actions. But I think that that's indicative of, again, the circumstances surrounding these offenses that, of course, I guess it seems everyone in front of the court these days is finding mental health issues as something that mitigates their criminal conduct. But I do think that in this case it is well documented, going back again to her military history, that she has suffered from mental health issues. I think probation is an option with the court. Obviously, these are state jails, and the court can put her on probation. And I know that the pre-sentence report.
Defense counsel pushes back fast, calling the state's approach unusually harsh and warning the court against turning this into an example case. He argues she's entitled to standard jail credit and says her mental health history is documented, dating back to military discharge. He paints the thefts as a spiral of untreated illness, self-medicating, and survival mode, while trying to convince the judge this is more than just another repeat offense.
Sentence report, you can look at that, tends to indicate, doesn't really indicate that they're, while they're not recommending probation for Ms. Rio, they don't rule it out.
Well, let's not talk about probation.
Okay.
Yeah.
All right. I'm sorry, but there is a paragraph where.
Well, it is an option, but that's not realistic on what's going to happen today.
They were mentioning that she'd be assessed with a specialized mental health caseload.
I understand that.
So just to note that is in the report.
Thank you.
If the court isn't inclined to consider probation for Ms. Rio, then certainly I think that while she's serving whatever sentence the court gives her, she'd have the opportunity to try to reflect on her actions and perhaps reassess
Cuts
those.
off the probation talk before it even gets comfortable, making it clear this courtroom isn't here for wishful thinking. The defense pivots, asking for something realistic: concurrent time, proper credit, and a shorter sentence. Then the defendant speaks again, apologizing and pleading for a chance to go home. She repeats the same heartbreaking theme, missing her kids' milestones, feeling exhausted, and begging for one last opportunity to fix her life.
Reassess those, where she is with this, and as far as addressing her mental health issues when she gets out, that she'll be able to do that and maintain her law-abiding lifestyle. She has maintained employment, I think 3 years for the city of Beaumont, if you will. Is that right, Ms. Rio? She has maintained gainful employment in the past when her mental health is stabilized, and I would anticipate she would be able to do that in the future if she does have the proper mental health regimen. That would be the argument for probation, obviously, but the court's not inclined to do that. So we would ask for a sentence, certainly, that would be concurrent and that she would be given her jail credit, but then something along the lines of 12 months state jail.
Thank
Do
you.
you want to address the court?
Right, I just want to say that I do apologize to the court, and I apologize to mom. And I'll be dealing with some things like new job, but I just want to get a chance to get home and take care of my kids. I miss graduation, I miss prom, my whole senior year. I got a 5-year-old kindergarten, and my mom got to take care of. I'm just tired. And I want the opportunity to get my life together. I'm tired of this. I'm tired of this. I miss my daughter's graduation. She spoke. It was my graduation. I was not there. I'm tired.
But the judge doesn't soften. The court reminds her she's been given chances before. Multiple probations, all revoked, 5 felony probation failures on record. The judge lays out the pattern like a timeline of missed opportunities. Theft after theft, a robbery conviction, and now 4 more cases. And the blunt reality lands hard. No one put her here but herself, no matter how painful it is for her family.
I'm tired. My baby asks me why I'm the only mom. I'm not at mom's and muffins. This is embarrassing for my kids. I want to go for my kids. Mama, thank you.
Sure. So, Ms. Rideau, I understand that you're asking for a chance at probation, but you've had chances at probation, and you've been given these opportunities in the past for any kind of help and treatment and all of those things, and all of those probations were revoked. And you've had 5 felony probations revoked. 2 at one time, 3 at the other time. So I understand that they were kind of clumped together, but still, after those, all for thefts, you're here for, there was a robbery that you got some time for in 21, and then you're here now on 4 more theft cases. And so, I mean, it's unfortunate and it's sad for your family, but no one put you here but yourself.
The prosecutor steps in and turns her apology into a bigger community issue, saying store owners are the real victims who are tired of the same script. He lists the businesses hit, calls it the greatest hits of courtroom excuses, and demands stronger consequences. Then he pushes for stacking sentences and denying discretionary jail credit, framing this case as the perfect moment to finally draw a line in the sand.
Mr.
Judge,
Coleman, I know what you're...
Yeah, you've essentially hit the things that I want to hit. That in addition to what I put in my sentencing memo, I won't belabor that, Judge. The only thing I would add is she says she's tired of this. I tell you who else is tired of this. It's our local store owners and business owners who are tired of people just walking in and taking what they want from them. She stole from a sporting goods store, from JCPenney, from another clothing store on a couple of occasions. They're tired of it too. They're the same old song. Just different defendant. I apologize. Give me another chance. I've got all these issues. In fact, I go one step further than the same old song. It's the greatest hits, Judge. It's what you hear time and time again. And I'm sure she said it back in 2011 when she got probation. In 2014 when she got probation. In 2017, just I apologize. Give me another chance. I've got these issues. Judge, if ever there's a case to consider denying her the discretionary jail credit under the Code of Criminal Procedure, this is the case.
And it's my understanding with regard to that,
I
but
know it's kind of, it's just a, well, I don't say it's problematic, but
I can't give the max and do that.
that's my understanding.
That's your understanding.
Yes, that's it in a nutshell, Judge. And I just say,
Defense
this
tries
is
a
the case.
last angle argument, equal protection, asking what makes her different from other defendants with similar records. The judge responds carefully, admitting frustration with state jail limits but acknowledging the state's concerns aren't baseless. Then comes the warning shot. The court won't stack today, but next time it could happen fast. The message is clear. If she wants to be there for her kids, she has to stop.
And I just say, this is a case for that to be considered. And I also say this is the appropriate case to accumulate her for her sentence, Judge. She needs, in my opinion, some stronger medicine than what she's received in the past in order to impress upon her the fact that she needs to stop engaging in this kind of behavior, Judge. Thanks, that's all I have.
Thank you.
I would just argue from the standpoint of equal protection as far as the other defendants listed.
Well, so here's, speak up so she can hear.
I would argue from the standpoint of equal protection of laws, Your Honor, what distinguishes her from the other defendants that have been before this court who are similarly situated with similar criminal histories?
Well, here's where, okay, here's where I am on this. I don't disagree with Mr. Coleman. I appreciate that he's gone out and tried to figure out some stronger things to do on some of these cases where we are stuck with state jail felonies. I've been very frustrated with that in the past. I don't know that this is the one to start with either necessarily, but it's not going to be out of the realm of possibility, depending on someone's criminal history, what their prior sentences were, and I don't fully disagree that this isn't one of them. I'm not going to do that this time, but I do appreciate the thought that went into this and don't necessarily disagree that there's going to be a time that this might happen, including to you if you continue to do what you've been doing for your whole life. Because if you're back in here after today on a theft, I can assure you that Mr. Coleman will remind me what he asked me to do that I didn't do. And I will on that. Do you understand? So if you want to be there for your kids, then you got to figure out something other than stealing. I'm going to find in all of your cases that you entered your pleas of guilty freely and voluntarily. In cause number 23, DCCR 0928, find you guilty of the state jail felony of theft of property. Sentence you to a term of 24 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Cause number 23, DCCR 2106, find sufficient evidence to find you guilty and at this time find you guilty of theft of property. Sentence you to 24 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Clause number 23, DCCR 2107, find sufficient evidence to find you guilty, and at this time find you guilty of theft of property. Sentence you to a term of 24 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Clause number 24, DCCR 1925, find sufficient evidence to find you guilty, and at this time find you guilty of theft of property. Sentence you to a term of 24 months in the state jail prison. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases, I am going to run them concurrently, which means together at the same time. Part of the reason I did the 24 months is because I'm going to see that a state jail felony you can get. So next time, whoever's here, if it's me or someone else, is going to see that you have progressively gotten worse, your sentences have gotten worse, and when someone like Mr. Coleman files something asking that these run consecutive or that we deny credit, that's likely to happen. I'm handing you in all 4 of your cases the trial court certifications. These show that these were not agreements, and so you have not waived your right to appeal. You can talk to Mr. Kimler about that. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition or about how long that lasts, you can talk to Mr. Kimler. Good luck to you, ma'am. You can go back with the bailiff. Thank you for...
The sentencing becomes official and relentless. 4 separate guilty findings, each hit with 24 months, all running concurrently. The judge confirms she'll get lawful credit for time served, but makes the reason for 24 months unmistakable. It's the maximum, a paper trail for the next court if she reoffends. Then the judge hands her appeal rights and a firearm warning, ending with a cold final line, "Good luck, and take her back." Like the video, subscribe to the channel, and we'll see you in the next video.